Hi, my name is Aubrey, and my Hot Topic article was called Minor League Baseball Players Minimum Wage Overtime Claims Proceed to Class Certification Stage. And basically, what this article is about is my article is the second step in this case that these baseball players had filed. So they filed it back in July of, well, back in 2014, and in July of 2014, the first step went through. And so the reason why they filed a lawsuit was because these baseball players claimed that the MLB, which sets rules for minor leagues and the major league clubs, were violating federal and state labor laws by failing to pay minor league players the minimum wage overtime compensation and wages for off-season work. And it says most minor leaguers are paid between $3,000 and $7,000 per year for 50 to 70-hour work weeks during the 5-month championship season, and they aren't paid at all for required work during spring training and other times of the year. And the lawsuit was originally filed in the federal court in San Francisco by 3 individual players and was later joined by 40 more players. And they asked the trial judge in the case to allow the case to be handled as a class or a group lawsuit on behalf of all the players, since there was a bigger number than just 3 of them. And so the ruling in July was granted, the judge had granted conditional class certification, which is the first step in allowing a class action under the U.S. Fair Labor Standards Act. And a lawyer named Bobby Pori estimated the class could include 10 to 12,000 present and former minor league players since 2011. So the players' lawyers can now go and notify all of the former minor league players and find out which players want to opt into participating in the lawsuit. So that happened in July of 2014. And then in 2015 was the second step in class certification, which was on May 20th, which is what my article was about. So this is like the step, it was like a stepping stone, and the step in the right direction for the minor league players in their case. And so it was like a positive, it was something good for them. And so what happened was on May 2nd, 20th, the court dismissed claims against 8 of the MLB franchises, finding they did not have sufficient contacts with California, where the suit is pending, to establish personal jurisdiction over them. In the July 13th ruling, however, the court denied defendants' motion to dismiss, stating that the named plaintiffs, who are proposed as class representatives of the various state classes, seek to represent unnamed plaintiffs who were employed by these other franchise defendants on the basis that they suffered a similar injury. So to those claims, the court ruled that it is appropriate to defer addressing the question of the standing until after class certification. So as a result, the players have established a sufficient standing to pursue discovery by claiming that at least one of the named plaintiffs, so one of the one of the players, was denied minimum wages or overtime pay from each of the remaining 22 defendants, and that at least one of the named plaintiffs was employed in each of the states for which the players assert state wage and hour violations. The franchises have yet to reveal their defense to the specific claims. However, they may argue the players are exempt from the Fair Labor Standards Act of minimum wage and overtime pay and requirements because they are employed by a seasonal job. So rather than like a full-time career that goes on throughout the whole year, they're claiming that this baseball is a seasonal, so it's like maximum of 7 months. And employees of establishments that operate for up to 7 months per calendar year, or whose average receipts for any 6 months of the calendar year are not more than 1/3 its average receipts for the other 6 months of the year, are exempt from the FLSA's minimum wage and overtime requirement. So yeah, basically, it's a part-time career, so up to 7 months. So this ruling that they had made, or the rest of the article talks about other cases that are similar to this one, and that they kind of briefly mentioned, and this is helping with this current case. So one of the examples they used was the Detroit Tigers. They won a similar lawsuit in 1997 when Bat Boys sought overtime pay for their work in excess of 40 hours a week. The Tigers claimed the seasonal exemption as a defense and were successful as the court recognized that Tiger Stadium only operated on a 7-month schedule, making its operation seasonal. So that was the Detroit Tigers. And then another one was the Sarasota White Sox, which is a former minor league franchise in Florida. And they also won a lawsuit by claiming a seasonal exemption. It's my dog. Hi, Teddy. Where was I? Okay, so the court ruled that the team played in a 6-month season and made 99% of its revenue during the time period. The question of whether the franchises will be safe from the potentially significant wage and hour liability in this latest litigation, which is this case that I'm talking about right now, will be a close call. So this was what happened in May, and so they're waiting right now to see what's gonna, where it's gonna go. And I got a lot out of this article. First is about wage and hour laws. It's important to look at wage and hour liability for everyone who works, not just in sports and competitive or minor league, major league sports, but just in any aspect of working. I think in any job, it's important to look and to know like the contracts you're signing regarding wage and hours and all that kind of stuff, because so problems like this don't happen. I'm sure that this isn't the first time. Well, yeah, it's not the first time something like this has happened because of the other articles that they mentioned, or the other cases they mentioned. And so I think that it's important to read and to know what you're getting into and signing up for, because I don't know if these baseball players, if they're telling the truth, then I think that they really do deserve the money, and hopefully that gets settled. And so let me think. Yeah, I also learned about the FLSA, Fair Labor Standards Act, which establishes minimum hourly wages, overtime pay for work exceeding 40 hours, record keeping, and child labor protections. And so that the FLSA is not just in sports, but in obviously all types of jobs. And so, yeah, that's about it. If you have any questions, let me know.